Hi everyone, I'm Sabrina and I'm a lawyer at VarityLaw. Today I will talk about the difference between directors and shareholders within a corporation. First, what is a corporation? It's a business structure in which only the money and assets within the corporation is at risk. The assets under the directors and shareholders' personal names are safe. There are a few exceptions to this rule, which we will go over in our later videos. Directors and shareholders are the most important people within a corporation. Directors manage the day-to-day operations, including deposits and withdrawals to the corporate bank account, hire and fire employees, and sign binding contracts on behalf of the corporation. Although directors have a lot of power, they also have a lot of responsibilities. If the corporation declares bankruptcy, then it will negatively affect the director's credit. If the corporation owes employees their salary and there is no more money left in the company, the directors are personally liable, meaning their personal assets are at risk. The start and end date of each director must be filed with the government. This information is public. Anyone can find out who are the directors of a corporation, but usually through the use of a lawyer. Now, despite all of that power and responsibility, directors are not the owners of a corporation, so that's why they usually get salary and not dividend. So who are the owners? The owners are the shareholders. Share and shareholder information are not recorded by the government. That means that who are the shareholders is completely private. That's a good thing. However, because it's not recorded by the government, you must ensure you have a complete and updated corporate minute book, which is basically an internal document within the corporation to prove ownership. This corporate minute book can be done through a law firm like VarityLaw. There are different types of shareholders, including common and preferred shareholders. Common shareholders have voting rights, meaning they can choose who are the directors. Remember, directors are the ones who run the corporation. Directors and shareholders can be the same people. Preferred shareholders have no voting rights. They are passive investors who invest into the company and get returns in the form of dividends. To attract preferred shareholders, and common shareholders can give them priority, meaning preferred shareholders will get dividends and corporate assets ahead of common shareholders. Now, as an entrepreneur, you can choose more than two classes of shares, such as multiple common and preferred shares, each with different rules. Sometimes, corporations will issue employee option shares as an incentive to their staff. We'll talk more about this in our later videos. Lastly, if you have more than one shareholder, it is crucial to do a shareholder agreement at the beginning to avoid disputes and litigation down the line. The cost of litigation is usually 10 times the cost of creating a shareholder contract. Alright, that is all for directors and shareholders today. If you have any questions regarding your specific situation, please contact us by using the information below this link. On behalf of VarityLaw, thank you for watching. Until next time.